Wars of Freedom came out in cover using press in 2009. This is his latest book, How You Make the Press, Right Where It Belongs. He's also the editor of Law and Order. He has many editions so far. I'm the editor of a book about working. I say this because you put it clearly. I got to also a customer. We see that we make a Ripstein. Yes. Which has been very proud. So, Arthur, welcome to Tella. It's a pleasure to have you. Arthur will talk to us about Kant's legal and for about 20 minutes. Thank you so much.
Thank you. It's a great pleasure to be here. This is my first time in Latin America. Though, as Martin noted, I am a cousin of Arturo Ripstein, and Arturo has agreed that his next film will be called Delitos Privados, so we can share publicity. So, what I want to do today is talk to you about a new project that I'm working on, which is on Kant and the law of war. And the way in which I want to introduce that project is by talking about two features of the modern law of war, each of which seems compelling, and yet the two of which seem to be diametrically opposed to each other. So the modern law of war starts with the idea first made explicit in the Kellogg-Briand Act of 1928, and then made explicit once again in a more sophisticated way in the United Nations Charter in 1945, that the use of force is prohibited with the exception of national defense. That you can't go to war, as the Kellogg-Briand Act put it, as an instrument of national policy. Instead, war is outlawed, but somehow war is outlawed. Close to a century before that is the idea that there are a series of rules governing the ways in which war is conducted, and that these rules are the same for both sides in a war. That is, that if one side is the wrongful aggressor in the war, the other is a defender fighting with a legitimate ground of going to war, nonetheless the same rules govern the conduct of both. So this is the larger project to explain how these fit together, and I claim that Kant has an explanation of why these two things count as a single view, as parts of a single view. But you can notice, of course, if you reflect on it for only a moment, that they seem to be, as I said earlier, diametrically opposed to each other. Because after all, you might think that if national defense is the only ground of going to war, then in the ordinary course of events, in a war, there will only be one side that is acting defensively. We can imagine cases, and indeed there are historical cases, where each side is quite sure the other is about to attack, and so they both are acting defensively. But the Geneva Conventions don't say, well, since both sides think they're acting defensively, therefore it's okay. They say the same rules apply regardless. And so what I propose is a Kantian explanation of how the same rules can apply to both sides. And that explanation, which I'm not going to go into in detail today, has its roots in the very nature of national defense being the only legitimate ground of going to war. That's what I'll claim. So what I want to do today is talk about why national defense is the only ground of going to war. And the way in which I want to do it, I want to situate it within the broader Kantian project of thinking about concepts of right. Because, as many of you will know, the Kantian project of understanding right supposes that there's a distinctive morality that governs the legitimate use of force. There's a distinction between questions of right and questions of virtue. And of course, this is a familiar feature of what it is to lead or attempt to lead a morally upstanding life, often there's a question of virtue about whether or not you should stand on your right in a particular case. Someone owes you money and they can't afford to pay you back. Well, you're entitled, they owe it to you, you're entitled to demand it. Should you demand it or not? That's a separate question. So Kant thinks that the morality of right, the part of morality that is enforceable, is organized around the idea of external freedom. And the idea of external freedom, in turn, is, in its simplest terms, the idea that each human being is entitled to be independent of each other human being. No one is subject to the determining choice of any other human being. Kant puts this point in terms of what he calls the innate right of humanity that each of us has in our own person, which he variously glosses in terms of the Latin maxim that each is sui juris, each is his or her own master, by which he does not mean that each is engaged in some kind of self-mastery, but rather that no other person is the master of you. That's what it is for you to be a human being. That's what it is for you to be a bearer of rights. And one of the other features of the innate right of humanity is that it carries with it, not as something separate, but as an integral part, what Kant calls the right to be beyond reproach. That is, it carries with it the idea that nobody is presumed to have done wrong. Just as nobody is the servant of another by nature, so too no one is presumed to have done wrong. This idea of the right to be beyond reproach is going to play a central role in what I say about national defense and what follows. But what I want to do for now is just remind you of its centrality to our moral and legal culture. In our legal culture, it figures in the idea that the burden of proof lies with the person who's asking a court to do something. If I allege that you've wronged me, I'm not entitled to a remedy. Instead, what I have to do is convince the court that you have indeed wronged me. And if I fail to convince the court, then I'm not entitled to a remedy. So too in the context of the criminal law. If the police allege you have committed a crime, they have to prove it beyond a reasonable doubt. This same idea figures in the law of defamation, at least the law of defamation in everywhere except the United States of America. In the law of defamation, ordinarily, if someone says that you have done wrong, you can bring them before a court and compel them to prove it or withdraw their claim. If they defame you by saying you've done wrong, then they have thereby wronged you. Why? Because what they do is inconsistent with your right to be beyond reproach. Ideas for Kant form the basis on which all thought about right will develop. And in particular, they form the basis of the fundamental structure through which we understand the legitimate uses of force. And I'll talk much more about that in what follows, but let me just remind you of the four basic ways in which, in a civilized legal order, force might be authorized. And I'm going to suggest that all of them have to be in conformity with right, rather than in conformity with any other set of moral ideas. So the most familiar, perhaps, use of force in a civilized legal order, though it's conceptually familiar, probably few of us have much occasion to deal with it, is what we might think of as protective force, defending yourself against attack. And I'll talk much more about that in what follows, but let me just contrast it with three other ways in which legal systems authorize force. The first of these, or the second of my four, is what we can call remedial force. That is, if I have wronged you, you're entitled to a remedy against me. And what it is for you to be entitled to a remedy against me is not merely that I have to repair the loss you suffered or return the item that I took from you, but that you are entitled to call upon the state to compel me to pay that rent. And so if I fail to pay, my assets can be seized, my wages can be garnished, and so on. That's remedial force, because the point of it is to repair a wrong that has taken place in the past. Modern legal systems, and indeed all legal systems, also engage in punitive force, punishing wrongdoers. The punishment is a hotly disputed topic in legal philosophy, and I'm not going near any of those. I merely want to draw your attention to the fact that the precondition of punishment is that the wrongdoer has willfully broken the law. Why we punish, let's not worry about that. The point is, it's punitive. It is designed to respond to a past event. And the fourth kind of force in which modern legal systems engage is what we might think of as administrative force, which I understand very broadly. This is the traditional police power, but it's covered also by administrative law, and it's also covered by various forms of social insurance and redistributive schemes in which modern legal systems engage. The thing about administrative force is that it's used in order to require a particular person to do their part in some broader system of social cooperation. Traffic tickets, they're not really criminal law. They're more like administrative force. You are being compelled to pay and being threatened with needing to pay a fine so as to get you to do your part in keeping traffic moving smoothly. So too, if you pay your taxes, part of the taxes go to maintaining public roads. Some of them go to maintaining the wonderful parks that you seem to have all over Buenos Aires. And you can be compelled to do that. That is, your employer gets in trouble if your taxes are not deducted at source. And so they can be forcibly taken from you, but they're in the service of these broader schemes of social cooperation. So there are these four different types of force. And what I want to do now is suggest that if you think about the nature of the innate right of humanity that each of us has, that they enable us to understand why it is that national defense is the only ground of going to war. Now, this may seem like a tall order, so just give me a minute to fill in a few intermediate steps. The first intermediate step that I need to fill in is that Kant has an argument, which I will not rehearse here, that explains why it is that human beings need to leave what he calls the state of nature and enter a rightful condition. Basic structure of the argument is to claim that rights are improperly protected outside of a rightful condition, in which you have a public authority capable of making, applying, and enforcing law. And so you need to leave the state of nature, enter a rightful condition. And when you have done that, the rightful condition is then itself, in a fundamental sense, a new kind of moral person. It's a new kind of moral person because when we come to the question of war, that I really am going to get to very soon, the question of war is always, in the first instance, a question of how things stand between different states, how states react to each other, and how they interact with each other. And my suggestion will be that just as each individual human being has a right to be independent of all other human beings, so too, each nation has a right to be independent of all other nations. And once we understand that, we will understand why it is that the grounds of going to war are restricted to national defense. So let me say just a little bit more about this idea of nations as independent moral persons. This idea has several parts to it. The first part is the thought that each nation wrongs no other nation by the mere fact of its existence. The fact that there is across the river Uruguay is not a wrong against Argentina. To say it's not a wrong may overstate it. It's neither a wrong nor not a wrong. It's simply the situation in which they find themselves. There's nothing wrongful about one nation providing, nothing wrongful as against another nation about one nation providing a rightful condition for its inhabitants. There's another implication of this, which I'll just mention here and not develop in any detail. And that is that each nation's relation to its territory is much more like a human being's relation to his or her body than it is like an owner's relation to his or her property. The reason I say this is that one of the fundamental features of property is that your claim to property always depends on how you acquired it. The only way that Martin can prove that this is his book rather than my book is showing that he acquired it in the right way. He can show that by showing where I signed it for Martin. So that's an easy one. But the point is, for property, your claim to anything that you own depends upon the procedure through which you acquired it. And if you acquired it rightfully, then you have good title to it, at least as against other private persons. That doesn't mean that the state can't tax it, doesn't mean that the state can't expropriate it. It means that if you think just about how things stand between you and every other private person, your claim to property depends upon the way in which you got it. And you got it either by acquiring it from an unowned condition, or acquiring it from another person, or making it out of things that you acquired either from an unknown situation, unowned condition, or from another person. And so all of those things govern your right to property, and none of them is true of a nation's right to its territory. The reason that a nation has a right to its territory is that it is providing a rightful condition in that territory. That's why the fact that, although as a matter of history, most of the borders of most of the nations in the world are the result of war and injustice, they're nonetheless entitled to their territorial integrity, because it doesn't matter how they got it. Now, I want to press this point further and to suggest to you that once we see nations standing in this kind of relation to their territory, we see further that their right to their territory is formally analogous to the innate right that you have to your own body. Because notice that you didn't acquire your own body. Presumably you acquired the food that you ate that makes up the matter of your own body. But of course, even if, I'm not suggesting that this is the case, if you acquired any of that food non-rightfully, it doesn't matter. Your right to your bodily integrity is just the right to your bodily integrity, because your body is your person. It's just your person in space and time. That's why wrongs against the body are wrongs against the person. So you have a right to your own body, and it doesn't matter how you acquired it. Now, of course, as it turns out, the way you acquired your body can't even be really given a coherent description, because you and your body arrived on the scene together. There was no you to do the acquisition prior to your acquisition of your body. Maybe some theological account is true, and your soul was put into your body in some way or other, but as Kant remarks, we can have no insight into how even an omnipotent God could do such a thing. That doesn't mean it didn't happen. It means that how it happened doesn't matter. Your right to your bodily integrity does not depend on us understanding how God could have given you a soul, or how you could have evolved with the faculty of reason. It's just you're a rational being and you are embodied. So too, I want to suggest with a nation's territory. It has jurisdiction over the territory over which it provides a rightful condition to its inhabitants. And its claim to that territory doesn't depend on how it acquired it. It simply depends on the fact that that's where it exercises jurisdiction. Now, on a Kantian view, there are all kinds of norms governing the way in which a state should rule over the territory where it has jurisdiction. But Kant's point is that's an internal matter for the state, and that is, provided that it really is providing a rightful condition, irrelevant to the claim of any other state against it. So its right to its territory is like its right to its body. Now, I want to push this idea of innate right a little bit further, and I want to suggest to you that once we see this, we see also that states must be entitled to be independent from each other simply as a matter of their standing as states. And I want to make this point through a brief historical digression, but let me do a pre-digression digression to clarify that when I say that Kant has the right way of understanding the modern law of war, I am not claiming that he shaped the modern law of war. I'm not claiming that if only you dusted the Lieber Code or the Hague Convention or the Kellogg-Briand Pact carefully enough, you would find Kant's fingerprints all over it. I'm claiming indeed that Kant is not reporting on the law of nations in his time, because what he says is nothing like the law of nations of his time. He's rather giving a formal characterization of how things must be. And so, with that in mind, here's the historical remark. In 1928, many of the nations of the world signed the Pact of Paris, the so-called Kellogg-Briand Pact, which outlawed war as an instrument of national policy. The great international lawyer Hersch Lauterpacht remarked that until the Kellogg-Briand Pact was signed, the international law was inherently legally defective. There was international law, but it wasn't really quite international law by its own standards. And the way Lauterpacht put this point is that you can't have a set of legal relationships unless the parties to those relationships are properly independent of each other. And you can't have the parties to those relationships be properly independent of each other if one of the parties can unilaterally deprive the other of its legal status. But the pre-1928 right to go to war was exactly that. The pre-1928 right to go to war essentially entitled any nation to, on the basis of whatever claim it asserted, the 18th century philosopher Vattel called this a pretext. On whatever pretext, if it could simply go to war, then it turned out that whether or not one of the parties had any rights would depend on what another party thought about it. But that is to say, no one had any rights. So international law was neither properly international nor properly law until war was outlawed. That's Lauterpacht's claim. So let's think a little bit about the pre-1928 law of war. The pre-1928 law of war basically said that law was legal as an instrument of national policy. And there were two traditional ways of thinking about how that could be so. These two traditions developed in early modern Europe, and though they had each had many exponents, I'm going to pick the Salamanca scholastic Francisco Suarez as my exemplar of the first approach, and the Dutch jurist Hugo Grotius as my exemplar of the second. For Suarez, war was understood enforcement procedure. That is, it was understood as something that could be done in order to address a wrong that had occurred. For Suarez, there were multiple categories of wrongs, and Suarez was actually quite fascinating on this because he thought he began his treatment of war by arguing that the standard justifications for the Spanish conquest of the Americas were all unsuccessful. First 250 pages, and you think he's opposed to this, and then he comes up with his own justification. Because for Suarez, war was fundamentally an enforcement proceeding. And as an enforcement proceeding, that meant that it was like the police coming and arresting you, or like the police coming, arresting you, taking you to jail to be punished. That was his picture of the nature of war. And Suarez understood that this had an uncomfortable element to it, because in the case of any war, the prince who was prosecuting the war would typically be a judge in his own case, since the prince would be punishing typically a wrong against his own principality, or perhaps reclaiming something that was wrongfully taken from his own principality. And Suarez worried about this, but he said we can trust princes to have good advisors, and so they'll only do this carefully. And so, therefore, they can legitimately go to war. By contrast, private persons can never go to war, according to Suarez, because when they have a dispute, they can go to the prince to have it resolved and enforced. But where there's no superior to the prince has to enforce on his own. So this one picture says war as an enforcement proceeding. Another way of thinking about Suarez's picture is that for Suarez, war is typically a matter of punitive force. Sometimes remedial force, other times punitive force. And I should mention that in his treatment of the Spanish conquest of the Americas, he actually thought that it was also partly a matter of administrative force. One of his arguments was that the indigenous peoples of the Indies, as he called them, were not using the land intensively enough. And so since God had given the land to all human beings in common to be used, they were stopping people from using the land as God had willed. And so they were being made to contribute to the world project of seeing to it that the earth was used. And so that you get a bit of remedial force, a bit of punitive force, and a bit of administrative force, all brought together in Suarez's conception of war. Grotius has a different view of war. Like Suarez, he thinks that if you're within a legal order, you're not allowed to use force, that all uses of force must, within a legal order, must be subject to the rule of the sovereign, who has a monopoly on the legitimate use of force. And so if you and I have a dispute, one of us can take the other to court. And that's the way in which our dispute will be resolved. Why is it that it can be resolved in that way? Well, precisely because the sovereign is our superior, we are the sovereign's subordinates, and so what the sovereign says goes. But what happens when there's a conflict between two sovereigns? A sovereign is, on Grotius's understanding, someone who has no superior. But if you have no superior, then it can't be the dispute by seeking the judgment of your superior. You can try and resolve it peacefully, but if you can't, then you can resort to war. And Grotius's book, The Law of War and Peace, is structured the way a traditional Roman legal treatise is structured. Part 1, what is war? Part 2, what are the causes of action? Part 3, what are the procedures? And the procedure, according to Grotius, is essentially one of seeing to it that the dispute is resolved. Why? Because the parties accept that they will resolve their dispute in this way. And so we hand our dispute over to what he, following a series of medieval writers, calls the dice of Mars. We let war decide. We could have, of course, decided by rolling dice, literally. We could have decided by having champions fight, something Grotius briefly suggests. But he notes that the problem with having champions fight it out is that if your champion wins, I might decide not to go along with the result. The nice thing about war, from this perspective, not a nice thing about war, is that it's a self-executing procedure. The one who wins the war wins the dispute, and there's no further enforcement action. So what's wrong with both of these pictures from a Kantian perspective? Each of them can be made internally compelling, and I've done a little bit to try to suggest the way in which people might so find them. But the fundamental feature that's wrong with both of them, according to Kant, is that they're both legal models of war, and they're both models of war in which the fundamental feature of legality is absent. Lauterpacht said the fundamental feature is that each is independent of the other. Kant says that's right, but the fundamental feature of that fundamental feature is that something can only be a properly legal proceeding if it's structured by the right to be beyond reproach. And neither the scholastic idea found in Suarez of war as an enforcement action, nor the regular war idea found in Grotius of war as a procedure for resolving disputes is actually structured by the right to be beyond reproach. If a state engages in a punitive war, its engagement in that war is not structured by the presumption that the person who it's attacking, that the state that it's attacking was entitled to do what it did. Instead, a punitive war and a remedial war actually presuppose that the question has already been decided. But if the question has already been decided without a procedure structured by the right to be beyond reproach, then it's not a legal outcome. It's just the use of force, and it is just, in Kant's technical vocabulary, barbarism. It's force with neither freedom nor law. Well, what about the idea of the belligerents submitting their dispute to the dice of Mars that we saw in Grotius? Well, that too is not a matter of a mode of dispute resolution that is structured by the right to be beyond reproach. Because there's no presumption that anyone is entitled to anything. Indeed, one of the clearest examples of this, which is discussed not by Grotius because it happened a century later, but by Vattel, another great legal scholar of the 18th century, is the War of the Austrian Succession, where Princess Maria Theresa became the queen, and she thus became the ruler of Silesia. But her cousin Frederick the Great said, no, look, here's Grandpa's will, he left it to me. And they went to war over this. They fought a series of pitched battles, and Frederick the Great won based on his claim that there's a will. But notice, he did not assume that Austria's possession of Silesia was rightful. Instead, he structured the procedure, the so-called procedure of going to war, on the assumption that it was non-rightful. But that's another way of saying that the fundamental problem of war, the fundamental problem of any situation in which might makes right, is that it's inconsistent with the right to be beyond reproach. So, I've suggested to you that there are 4 different ways of thinking about the legitimate use of force: protective, remedial, punitive, and administrative. And I've noted that that remedial, punitive, and administrative force figure in the just war tradition of Suarez and in the regular war tradition of Grotius, and none of them can be rightful. I have so far said nothing about the use of defensive force, and it is to that I now want to turn, and I want to suggest that defensive force is distinctive because the use of defensive force can be consistent with the right to be beyond reproach. Let me put the point this way. You might think that if you are attacking me, and I presume you to be wrongfully attacking me, then I am assuming you to be a wrongdoer. And so any defensive force I use would be inconsistent with your right to be beyond reproach. There were too many yous and me's in that, so let me take you through this a little bit more slowly. If one person is defending him or herself against an attack by another, the defender seems to be making a judgment about what the attacker is doing. And that seems to be the ground for the defender's use of force against the attacker, but we might worry that that ground is inconsistent with the attacker's right to be beyond reproach, the attacker's right to be presumed to be doing no wrong. But I want to suggest to you that, in fact, if you think carefully about the way in which self-defense works, you will see that that's the wrong way to think about it. And that, in fact, self-defense is just the minimal case of each person's right to be beyond reproach. Because if one person is attacking another, they are doing something that is inconsistent with the defender's right to be beyond reproach. Because to unilaterally attack another person is to attack them for no reason, is to attack them without having first established that they have done wrong. But if someone is acting in a way that's inconsistent with your right to be beyond reproach, you can stop them from doing that. Why? Because your right to be beyond reproach just is your most basic right to juridical standing, your right of humanity in your own person. What that means is that the attacker is the one who's acting inconsistently with the right to be beyond reproach. And so the defender must be enacting in a way that's inconsistent with that inconsistency, acting in a way that's consistent with it. So my suggestion then is that there's something different about defensive force. Now, so far I've been talking about defensive force only in the individual case, but notice that it carries over directly to the international case. In the international case, if one nation violates the territorial integrity of another nation, then it is violating its territorial integrity without having established that its possession of that territory is wrongful. And so it's acting in a way that is inconsistent with the right to be beyond reproach. Now, that means that it is a wrongdoer, presumptively. And that means that, at least presumptively, it can be stopped from completing its wrong. Now, this raises two questions. One question is an epistemic question about the limits of human judgment and about the ability of people who are under attack, whether individuals or nations, to actually make a correct or reliable judgment about whether they are under attack. Because of that, it may turn out that in certain circumstances, you have, that this is something I mentioned at the beginning, two nations are attacking each other, each of them believing that the other is attacking it. And in the moral philosophy literature, there are all of these examples involving identical twins, where the escaped murderer has an identical twin, and the escaped murderer the identical twin shows up at your door, and you think it's the murderer, and so you use defensive force. The identical twin knows nothing. They were separated at birth, knows nothing about the murderer or the murderer's escape, thinks you're attacking. And so maybe there are sometimes cases like that where there just isn't enough information. The Kantian view does not say that this can never happen. It says that the only thing that is consistent with the right to be beyond reproach is using force against an aggressor, and then the fact that we have imperfect knowledge of what we are entitled to do means that whenever you use force against an aggressor, you're taking a moral risk, because it may be that this person is not actually an aggressor. There are various histories of the Six-Day War between Israel and its Arab neighbors, according to which both sides thought that the other was about to attack. I don't know if any of these stories are true. It's not my aim to take a position on that here, but I merely note this could happen, whether or not it actually does. But that's not relevant to the question of whether defensive force is warranted. But the other complication about which you might ask is whether, when it comes to the wrongfulness of aggression, why it is that the wrongfulness of aggression necessarily entails the right to use defensive force. You might think instead that aggression is wrong, it's appropriate to outlaw the use of force, but there's no exception for national defense. That if aggression is wrong, you can never use force, and that's the end of the story. The Kantian account says no, you're actually allowed to use force in this case. And the reason that you are is that if we think about, in the individual case, your innate right of humanity in your own person, or in the international case, the nation's right to territorial integrity, you see that in order for that to properly be a right, it must be something that another person or nation cannot take away. Now, the only difference between a system in which all force is outlawed and a situation in which all non-defensive force is outlawed will come up in the situation in which in which one state actually engages in aggression, because otherwise they're exactly the same. If everyone abides by the prohibition on the use of force, then no force is used, and so no defensive force is warranted, so no defensive force is used. It only comes up in the case in which there is aggression, but if it is to be a system of rights, it has to be that whether you have a right or not doesn't depend on whether others respect that right. That's why rights are always presumptively enforceable. That's why if I take your pen, I have to give it back. The fact that I have wronged you doesn't make you stop having a right to your pen. The fact that I have attacked you doesn't make you stop having a right to bodily integrity. And in the international case, the fact that I have invaded you doesn't make you stop having a right to territorial integrity. But if you still have the right, that right has to be made effective, which is to say defensive force can be used. So what I've done so far is suggest to you an analogy between the human body and a nation's territory. And I've suggested that when we look at that analogy carefully, we see that in the absence of legal institutions, the basic right that you have to your own body, or the basic right that a nation has to its own territory, includes only one enforceable right. That is the right to defend your independence and bodily integrity, or a nation's independence and territorial integrity. That means that the other types of force, remedial force, punitive force, and administrative force, are only available when publicly authorized through a legal order, of which the person against which the force is being used is properly a member. I want to conclude by distinguishing Kant's argument about the nature of defensive force from a familiar form of argument, which Kant rejects in Perpetual Peace, that claims that preventive force is also legitimate. A preventive war is a war where one nation attacks another because, although the other is not in the process of attacking it, it menaces it by its mere existence. Kant gives two examples. One is the example of a large state that worries that its small neighbors will unite against it. His other is an example of a small state that worries that a large state will overwhelm it. And what Kant says is that a maxim of preventive war, a rule licensing the use of preventive war, can't be rightful because it could never succeed if it were made public. That is, if the other side knew that this was how you were operating, it could never succeed. Now, when Kant says this, he has struck many readers as engaging in unlimited political naivete. Because, of course, whether you can announce your plans in advance and still succeed with them, as a matter of fact, depends ultimately on how strong you are. And so the United States in the 19th and early part of the 20th century could announce the Monroe Doctrine and manifest destiny. Guess what, the rest of the Americas, we're going to take you over. And although they could announce that, and they met with at least some success in doing that, but Kant's claim is different. The point about publicity is not that it is self-defeating for a particular state on a particular occasion to announce that it intends to engage in preventive war. His claim is rather that engaging in preventive war can't be available as a means of securing your own nation. Because if you were to announce in advance that you plan to engage in preventive war, that every other nation threatens you by its mere existence, then you would announce to every other nation that you threaten it by your mere existence. And to announce that is, of course, to make yourself perhaps not factually vulnerable, that depends on their strength, but make you in principle vulnerable, because what you've done is repudiate the possibility of any form of interaction other than through force. And that, though it may be that you can be successful in that, you can't improve your success by announcing that that's what you're going to do. You can, if anything, only damage your success. So the reason I mention preventive war here is that you might think that there's a tension between Kant's claim that defensive war is legitimate and his claim that preventive war is not legitimate. Because after all, you might also think that you're entitled to defend yourself before the attack has fully begun. You don't need to wait until the bullet has left your enemy's gun. You don't need to wait until the enemy troops have poured across the border before you're entitled to engage in personal or national defense. Instead, you can act preemptively when an attack is in progress but not yet completed. And so you might think, so why isn't this just a license for preventive war? The answer is that although preemptive war can be legitimate in order to preempt an attack that's already underway, it has to be actually defensive It has to be against an actual attack rather than against the mere threat that someone else poses by being independent of you. Because it turns out the limitation to defensive force is just the independence that each nation has as against the others. But that means that that same independence is also the prohibition on preventive force. You can't use preventive force because every other nation is independent of you. You can use defensive force because you are independent of every other nation. And so the two come apart. Let me conclude by noting that this Kantian view limits the grounds of war to defensive force, and in so doing, it might be thought, leaves things too wide open. Because in most wars, since 1928, the nations fighting the wars have claimed to be acting in national defense. When Nazi Germany invaded Poland November 1st, 1939, it's November 1st, Hitler expressly said that it's because Poland was in the process of invading Germany. There was no truth to it, but the question is, what good is a limitation to national defense if, as it turns out, people are going to invoke it all the time? Where Vattel allowed a long list of pretexts, here we have a narrow, single ground of war, but people will always claim they're defending themselves. To which the answer is, the reason that morality matters and the reason that law matters is that they are the ways in which we can organize civilized relations with others. The possibility that someone will abuse a moral or legal justification does not show that that justification counts for nothing. And indeed, if you look at many of the preposterous examples of claims to defensive force to mask what was in fact naked aggression, we can all agree that they're preposterous. By contrast, prior to 1928 and the prohibition on the use of war as an instrument of national policy, as it turns out, there were lots of claims made that were impossible to assess. Here we have a clearer standard, and although people will not always honor it, the fact that it's there counts for something. And it is the beginning of the possibility of eliminating war, and with it eliminating barbarism on things, is the final end of all right, perpetual peace. Thank you. Okay, so thank you. So let me start with the question of body and territory. It's certainly true that we think of bodies as having natural boundaries, and though some nations have natural boundaries, like boundaries or rivers, that is in some sense accidental. And also, of course, as I said at the beginning, each nation's territory came about through its history, usually a history of wars, and so the territorial boundaries of nations shift. My claim in drawing the analogy between the nation's territory and its body was not to claim that nations had their territory naturally, but rather that the kind of constraint of the conduct of other nations imposed by the nation's territory is like the constraint imposed on other people by your actions. That is, I'm not allowed to touch you because it's your body. And so the thought is that there's a series of questions that come up for property that don't come up for territory. Now, that's true. Those are moral questions that come up for property that don't come up for territory, even though as factual questions, they do come. I just told you they're relevant. And so, with respect to any nation's territory, you can ask such things as, in what year did Hawaii become part of the United States? And that seems to be a datable event. But the datable event has no bearing on the right of the United States against invasion by any other nation. And so, more generally, this is a structure of interaction that says these questions don't have a historical answers, don't matter. I want to just draw a very quick analogy here between this and Kant's well-known and notorious opposition to revolution. One of the things that Kant says about revolution is that it's futile to look with practical intent into the origins of a state, whether law came first and then force, or whether force and law only later, or whether it even matters which should under force. The claim of a legal order to rule in its territory doesn't depend on it having come about in history. It depends upon what that's the internal feature of a prohibition of revolution. But if the inhabitants of the territory aren't entitled to questions, neither is anyone something. That way, the point is the questions. Now, what about your example of, you gave two kinds of examples. I think with Catalonia, I'm not sure what to say about laws, about cases of secession, because secession seems to be fundamentally a different set of questions. It doesn't seem to me that this is a question of war, and so I'm not exactly sure what to say about it, other than to say the mere fact that some people are unhappy with the territorial nation is not in itself the ground for or the way that we see that is when we recognize that on a continent, a nation can only act through its institutions and officials, and all this again is part of the revolution. Even if the revolutionary says, well, I'm the true representative of the people, the fact that the revolutionary claims to represent people, no one can represent anyone except institutions. And so there's just a question about how this operates. Now, I understand like a minute ago, in Catalonia, you have different levels of government and you have different levels of representation. Now, what about the case? That seems to me to be a very interesting case, in part because part of the showed why a public authority needs to provide roads between any two locations on its territory, because otherwise anyone who wanted to visit someone else would be subject to the choice of going to land. That's a relation in which everyone has everyone else, and so we need public rights to guarantee this. And with it comes a series of other rights that come to the public. I have a right in another private person to block the public road, and I have further a right that other people, that if someone is a bridge keeper or a ferry operator, that they let me cross the river, whether or not they have likely 5 feet. So you get all of that as members of the state, as members of the public. Now, Kant also has a further category of what he calls cosmopolitan right, which is the rights that we have as citizens of the world, which are analogous to that. And this means that you have not a right to settle, but a right to visit, a right to cross another nation's territory on its public roads, so as to visit, to engage in partnership alongside of them. Now, I'm not sure what to say about whether that kind of violation of cosmopolitan right could give rise to right to home. And I think we have the country now does allow criminalization of why. Okay. 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 So let me start with the territory of the body, because I think that will actually give me resources that will allow me to respond to the question. So Kant's argument for the need to explicate the nation, which I alluded to in summarizing, therefore, without really explaining it, has many steps to it, and I'm going to simplify it somewhat. But the key idea is that in the absence of legal institutions, the state of nature is morally defective in 3 ways. And it's morally defective in relation to the concept of right. And so the first way, which is defective, is that although Kant thinks he has an a priori argument to show that no one does any wrong by owning property, there's no way property can be acquired rightfully. It can't be acquired rightfully because the acquisition of property is a unilateral act. I take the thing and I make it right. That changes the normative situation. And so there needs to be a proper public authorization of that in order for me to be entitled to engage in this. Second, in the absence of unified forms of enforcement, nobody has any reason to respect the proprietary rights of others. Rather, no one has any formal reason to, or would have material reason to, depending on the particulars of what they want to do. So on. The third is that concepts of right are by their nature indeterminate. They're indeterminate in the sense that they're highly abstract and they need possibility and specific. Now, without going into full detail of any of all of these 3 arguments, I want to draw your attention to the way in which they are parts of a single claim about the job of the state has. The state's job is to provide closure with respect to the rights of individuals. In order to do that, it has to have several features. It has to have mandatory authority, and it has to have exclusivity. All uses of force and all adjudication of claims of right are subject to the state's. What happened and where do they have it? Where the state exercises the authority. Now, what happens if another state comes along and interferes? The answer is they violate the exclusivity of that. And in violating the exclusivity of the authority, they are therefore wronging the inhabitants who have united themselves into a rightful condition and are entitled to be in that rightful condition. Because by uniting themselves into a rightful condition, they have done no wrong in anyone else. And so, therefore, the problem with the evasion is that it has this exclusivity. Now, what about humanitarian intervention? So, I mentioned Kant's opposition to revolution, and unsurprisingly, just as we complain about his opposition to revolution, so too they're likely to worry about what appears to be an opposition to humanitarian intervention. Kant draws a distinction between 4 forms of political action. The first of these is what he calls a system of anarchy. It's a pure state of nature, but one in which, as it turns out, everyone respects the rights of others. It's a system of freedom with neither force nor law. This is just a hypothetical type, but we can understand it. The fourth is a system of republican government in which the citizens rule themselves through the laws, and you have a combination of force and freedom. For might is disciplined by right. There's a defective version of each of these. The defective version of republican government is what Kant calls despotism, where you have force and law without freedom. There's also a defective version of anarchy. The defective version of anarchy is what Kant calls barbarism, neither freedom nor law. the thing about barbarism is that it's not, so despotism is a defective form of the rightful condition. Barbarism is not a defective form of the rightful condition. Barbarism is a defective form of the state of nature, which is to say it's not a rightful condition. So what happens in these horrific cases where humanitarian intervention is justified as opposed to cases it's clearly justified? The answer is that in genuine cases, the only ground for humanitarian intervention seems to be is barbarism. And the mark of barbarism is the condition in which there are human beings with no rights. Now, where is that? Where does that happen? What are the cases of that? Genocide is the main case of it. I think that institutionalized slavery is a case of it. And I think that limits limits. And so I think there are grounds for humanitarian intervention, but the humanitarian intervention is not a ground of going to war. It is a ground of stopping a massacre so there are rightful conditions. Now, the further thing to say about these kinds of cases is that humanitarian intervention in these cases can be rightful. And then there's a very hard question about whether it's actually appropriate. Okay. That if you have a realistic prospect of living alone. So if you look at that intervention, there's a question about whether they're entitled to do it, because although I talked only about the grounds of going to war, the rightfulness of the war also has other kinds of conditions attached to it, one of which is a reasonable prospect of success. Now, there's a particular Kantian spin on that, and so I actually think that the mere fact that you are resisting an aggression to do something at which you have a reasonable prospect of success. And so I think, for example, that Poland was entitled to fight back against Nazi Germany, even though the likelihood of victory was not high, and a prospect of success in resisting aggression. When it comes to humanitarian intervention, the contours of the prospect of success seem to me to be different. It has to be that there is a prospect of stopping the massacre and creating life conditions. And obviously there's no certainty about that, but those factors. Okay. Technical vocabulary. Okay, well, so you've asked a number of questions, and let me just start with the question of analytic versus synthetic law, because Kant says that the principle of right that entitles you to enforce rights is analytic rather than synthetic, because it doesn't specify the end. And my claim would be that the right to defensive force in the international case is analytic in the same way, because it just is the independence of states as against each other. Now, that turns out to push the question back to your second and third questions, and I will come to those in a moment. But the basic thought is that what it is for states to be authoritative within their territory is for them to be independent of each other, rather than dependent on each other. And once we see that, then we see that then, coming to your question, well, the name right is prior to any juridical act. How can we say this about states? The answer to that is that we need to distinguish between different types of juridical acts, because for Kant, that the great thing about Kant, my favorite course to teach is actually the critique of reason, because there's only one idea. There are two distinctions, and then the whole thing is just applying the distinctions to themselves over and over and over again until you have actually spoken. And so it's really, really thrilling. But one of the distinctions is the distinction between form and matter. And of course, Kant has a whole hierarchy of form-matter distinctions. So too, Kant has a whole hierarchy of, so that the question of what is and is not a juridical act always has an internal and an external aspect once you get to the idea of public right. Because what is internally the constitutive juridical act of the people uniting itself, a multitude of human beings uniting itself under law, is externally prior to the juridical act, which is to say that there is nothing that the multitude of human beings needs to do in so uniting itself in order to be entitled to independence as against other peoples. And so, because there's nothing it has to do, it is prior to any juridical act. This is also to return to Horacio and Eduardo's question, why the nation's territory is like its body, because there's no juridical act in which it has to engage in order to do that, because just as there's no you until you're embodied, there's no state until it occupies space. And so, until it has territory, it isn't a state. And once it has territory, it's a state, regardless of how it is. And so there's no, although there are lots of juridical acts, there's no relevant juridical act. And so that's why it'll make it. So let me now connect this to popular sovereignty, and then I will answer your question about the world republic as opposed to federation. The issue about popular sovereignty is that popular sovereignty is a conclusion rather than a premise in the Kantian argument. The people are sovereign not as the constitutive principle of a rightful condition, but as the regulative principle of a rightful condition. A rightful condition can be satisfied by anything that meets the conditions of the postulate of public right, which is to say anything that meets the conditions of having institutions for making, applying, and enforcing law so that everyone can enjoy their rights as against each other. And so the people are sovereign because that is the regulative principle for a rightful condition, the people actually actively ruling themselves through the laws. And that is what Kant calls the idea of the original contract. But notice that we need to distinguish between the idea of the original contract and the postulate of public right in order to have, first of all, Kant's explanation of how a despotic system can still be rightful, and so need to reform itself but not be subject to revolution, and to explain why a state does wrong in invading another state. Another way of seeing the sense in which popular sovereignty is a conclusion rather than a premise is to note that the wrong that is involved in one nation invading another has to be characterized as a violation of popular sovereignty, even if there is no datable event, and so no juridical event of the constitution of popular sovereignty. So John Simmons has a recent argument which explains that Kantian theory of the state is purely functional, and so anything that does the job of making applying and enforcing laws is just as good as any other. And he said, and then he illustrates with an example. He says, imagine if the United States invaded a 1 mile strip of Mexico, and annexed it to the United States, and they made and applied law, and it was a bloodless invasion, and everything went well, and then there. And he says the Kantian can't say what's wrong with this, but in fact the Kantian can say exactly what's wrong with this, but only because the existence of a rightful condition entitles us to conclude that it is an instance of the original right of the people to unite themselves under laws, and they've interfered with that. And so, whereas Simmons says, no, you have to have an actual agreement, but then it turns out Simmons can't explain territorial integrity. There's nothing wrong with annexing Mexico, since the people of Mexico were never, the current people of Mexico were not unanimously consulted on it. So I want to say we need to bring sovereignty in after the claim that each nation has as against each other nation is going to be a claim to sovereignty because each is entitled to it. Now, you want to know about a world republic as opposed to a federation? Well, obviously, a federation, both because that's what Kant says, but also because in well, some people still think, and some of my best friends still think, but they are mistaken. And the reason they are mistaken can be illustrated by noting that in the 3 definitive articles of Perpetual Peace, the first definitive article is that all nations shall have equal governments. The second is that there will be a free federation, and the third is that cosmopolitan rights shall be restricted to the right of universal hospitality. That those 3 actually are all mutually supported, and you could not have the other 2 of them if you had a little state. You could only have each of them if you have the other 2. And I have a complicated argument about that I will spare you right now. I can send it to you if you want. But the basic thought is that the possibility of people having different claims against their state than they do against other states is inherent in the possibility that if you had a federation of free states, you couldn't have differentiated rights. You would have a right to settle, and so you wouldn't have cosmopolitan right. And that might seem like a bad thing, but it turns out that that's not a bad thing, because Kant's argument against colonialism and his argument for differentiation are the same. And so you could only have a world republic of a rightful conditions. So that's it. Okay. Okay. So this was a heated issue in the 17th and 18th century. So Grotius spends almost as much time talking about alluvial islands as he does talking about war, because there's some cases where there's actually a problem, which is that the boundary is marked by some geographic thing and it shifts. There's an earthquake in the mountains, or there's a volcano and the mountain gets bigger, or classically the river shifts. So there's a question about what can be done there. And Kant's answer has to be that the one who is in possession is the one who's in possession. And the only way you can resolve the dispute is as comprehensive as it can be. And so now it's true that there will be these kinds of weirdo cases where it's not at all clear where it is. But most of the time, when there are territorial disputes, though they're patrimonial disputes. That is, each side is claiming that the other side, one side is claiming that the other acquired it. The Kantian view is that can't possibly be. Where it shifts, it's not, where the river shifts, it's not that they acquired it in the wrong way. There's no wrongdoing on the part of either nation. River shifts, I'm assuming. Someone damn it. But because that would just be an act of aggression. And it would be an act of aggression against which you could defend, even if it was not intended as aggression. It was just incompetence. But beyond that, if the river shifts, then what's on which side of it? And so the problem is, of course, there are two answers of it. One is that the boundary was the place where the river was, and the other is that the river was the boundary. And there's no unique answer to that, but the fact that there's no unique answer to that doesn't give anyone else cause to war. And so it seems to me that those kinds of things, though it's, well, let me put the point more abstractly, because you mentioned the analogy of knowing my body is. That's true, but that's not actually a relevant kind of indeterminacy. The way we can see that is we can know that islands and oceans have completely different bodies and ways in which human bodies, or boundaries in which human bodies have. But that doesn't mean that they're not subject to dispute. Why is that? Well, because they're things rather than persons. And so the claim to them depends on how they were applied. And so it isn't that disputes about territory come up because of lack of information or because of vagueness. That can happen. But the fundamental demarcation between the right to your own body and the right to property is that property depends on how you got it. Not that there are cases of vagueness. There are cases of vagueness for everything. And one of the nice things my friend in the club wrote a 300-page book on vagueness in law, and he had a long discussion about contracts case that he took out something that I did years ago, and it involved shipping of great food pellet, and so some of them were rotten. And so if you have one rotten pellet in a large cargo ship, obviously they're rotten condition, and if they're all rotten, obviously it didn't. And then there's this huge vague zone in between. But the solution to that is to say that if you need an impartial arbiter to resolve the vagueness, to pick this one as the cutoff from the shipping run. But although you need that, whatever point in the zone of vagueness the arbitrator hits, neither side can say, wait a minute, that's not what I agreed to. So too, when there is vagueness with respect to boundaries, if there's a dispute about vagueness, that's precipitated by vagueness, like the river shifting. In that kind of situation, you can have an arbitrator decide, and no one can claim that it was because neither can claim that there is an answer. So it seems to me that we can treat those cases. So your thought is that if we think of our body as being just the starting point, then this raises an objection to the thought that somehow talents are helping on. Yeah. Okay. So I think, well, so we could spend hours talking about whether Rawls is actually committed to this argument that these things are held in common, and whether this is something that Morgan and Killick and others have kind of put in his mouth. But putting that aside, it seems to me that this much can be said. The idea that you have a right to your own person is, on the Kantian view, a question of the claims that other people can make against you, other individuals. There's a separate question, so that's a question, as it were, of private right. There's a separate question, public right, about whether this, what kind of attitude the state should take, or is entitled to take, towards the abilities they have. And in particular, whether the state can impose on you certain kinds of requirements that amount to taking over your abilities. And I think on a Kantian view, it can't be that the state can do that in kind of a strong sense, which some people have suggested, because your entitlement to them is also, though it's not an entitlement against the state in the sense that the state can't make any demands on you. The only demands that the state can make on you are the demands that are already in subsidium of its duty of providing the right condition. And you and your fellow human beings are the right condition. And so, although the state can engage in all kinds of forms of redistribution to attack the nature of the rightful condition, it's not that the rightful condition holds its citizens with their habits in common. It's rather that each person is entitled to be like the others, and so can only be burdened by the state to the extent that doing so is required in order to maintain a system. Another way of putting this is that the Rawlsian setup focuses on benefits and burdens and questions whether you're entitled to the benefits. Kant never talks about benefits and burdens. It's all a matter of the rights that persons have as persons. And that doesn't mean that no burdens are created. It means that you can't start by saying you are or you're not